पहले पास ओवर करेंगे।
With your lordship permission, may I mention?
क्या mention?
लॉर्डशिप फर्स्ट अपील इसमें एडमिट भी हुआ है, कल तक नोटिस करना था, नहीं किया, आज कर दिए हैं, हम एक्सटेंशन ऑफ टाइम हम ही से
हो गया था।
हां
ये हो गया ना,
हां एक्सेप्ट भी हो गया, नोटिस हम फाइल नहीं कर भी गया,
फिर अब क्या
एक्सटेंशन ऑफ टाइम के लिए
जब तक प्रीएम्प्टिव ऑर्डर कल तक था ना,
कल तक था, आज हम लोग फाइल एक दिन का हुजूर देंगे,
एक दिन का सांस मिलता है किसी को, एक सांस भी नहीं मिलता है।
जो कहेंगे एक्सटेंशन ऑफ टाइम
आपको रेस्टोरेशन फाइल करना पड़ेगा, वो केस नहीं है, आपको रेस्टोरेशन फाइल करेंगे, हम रेस्टोर भी कर देंगे, नोटिस भी कर देंगे, ये मसला नहीं।
From this serial number 26, the response second list is का serial number 26 with consent on ये test mention कर रहे हैं, लिस्ट में था जो पॉजिटिव टाइम के चलते ये मैटर टेकअप नहीं हो पाता है। 33C2 का एग्जीक्यूशन प्रोसीडिंग का ऑर्डर अंडर चैलेंज है,
वही सेम कहानी 30 वही वाला
मैं उसमें इंटरेस्ट का कुछ नहीं कहा है, इसमें खाली अमाउंट का खेला गया है, तो इसमें इसको किसी दिन सप्लीमेंट्री लिस्ट में पोस्ट कर दिया जाए सो दैट दिस कैन बी डिस्पोज्ड।
कितना बहस करेंगे,
3 लाख रुपए का लायबिलिटी हम लोग पर डाला है,
तो आप क्यों परेशान हैं, पेमेंट करिए,
इसको सुन लिया जाता है तो आप
क्या
हो
क्या
जाएगा।
ग्राउंड बनाए,
ये कहीं दूसरी जगह काम कर रहे थे, एविडेंस वहां से लाए हैं, सारा एग्जिबिट नीचे हुआ है, बहुत छोटा सा इशू है,
पूरा अमाउंट अवार्ड हुआ है।
हाँ पूरा और पूरा कंप्यूट कर दिए हैं पूरा, जैसे जिस दिन उनको ज्वाइन कराने का ऑर्डर हुआ था वहां से लेके पूरा कंप्यूट कर दिए हैं, तो किसी भी मिस्टर एक मिस्टर कॉन्सेप्ट ले चुके हैं,
वो तो आगे मिस्टर सानी छोटा सा मैटर है 33C2।
हां बोला नेक्स्ट वीक में कोई भी डेट फिक्स कर हम कर
ये तो हो जाता है, लेकिन ये एडमिशन हेडिंग में काफी नीचे चला है।
देखिए तो कौन सा दिन खाली
सीरियल 26
नेक्स्ट टू नेक्स्ट वीक में डालें। कल हम लोग के पास बेसिक है, आज के कुछ मैटर्स जा रहे हैं ना अराउंड डेली, कल तो लगता है कि नहीं हो पाएगा,
का तो रेफरेंस है,
ठीक है नेक्स्ट थर्सडे
सप्लीमेंट्री लिस्ट में
सप्लीमेंट्री
हो जाएगा।
इतना केस क्यों इकट्ठा करके रखे हुए हैं, क्यों नहीं पहले किए सब,
रिजाइडिंग ऑफिसर नहीं वो तो खत्म हो गया सर, ये उसी के बेस से
तो उसका जो डीएमडी हो गया था वो रेस्टोर होकर ऑर्डर हो गया,
नहीं अब नहीं करना है उसमें, ये आप ऑर्डर कर लीजिए पेमेंट करना, अब आगे लड़ाई
नहीं अभी क्या, अभी ये कोई मेंशनिंग टाइम तो नहीं है, अभी मेंशनिंग टाइम नहीं,
कंफर्मेशन ऑफ सर्विस टाइम भी सीट से ही आया था
कंफर्मेट देखिए ये एक मेंशनिंग टाइम नहीं है, इस वक्त हम कोई मेंशन नहीं
from 10:30 daily list password case item 50 PA 3982 of 2026
कितने केसेस हैं ये,
तीन केस
तीनों फाइल,
चार केस 55 में
सबसे पहले कौन सा करना,
50 that is 3982 राजेंद्र मंडल,
राजेंद्र मंडल,
yes
चार्जशीट हो गया,
चार्जशीट सबमिटेड, रिकवरी ऑफ
राजेंद्र मंडल का क्या है,
150 में turned up, amount of 3,700.
What has been recovered from you?
From the possession of this video, the recovery of 2 mobile sets with 3 SIM cards.
2 mobile
With 3 SIM cards.
3 SIM, all belonging to somebody else.
Yes. No antecedent. Custody since 18/3/26. Charge sheet submitted on 15/6/26.
Custody.
Custody since 18/3/26.
Charge sheet on
On 15/6/26. One victim, amount of rupees 3,799.
और crime link
No crime link described in the case.
नहीं
No.
कोई भी पकड़
Persons have been large.
The learned counsel for the petitioner submits that the petitioner, having no criminal antecedent, is in custody since 18/3/2026, and charge sheet has been submitted on 15/6/2026. One victim has been identified. There is alleged recovery of 2 mobile and 3 SIM standing in the name of other persons. The learned counsel for the state has posed a prayer for bail. However, the posted submissions made by the learned counsel for the petitioner is not in dispute. Considering the fact that petitioner has no criminal antecedent and charge sheet has already been submitted, the petition is directed to be enlarged on bail. तो ये राजेंद्र मंडल ये है 3982. अच्छा एक चीज और he submits that co-accused namely Kundan Kumar Mandal and Ajit Kumar Mandal have been enlarged on bail in VA number 4702 of 2026 and 4972 of 2026. Right order dated 29th May 26 and 4th of June 26. Order time next is
Next is Ujjwal Kumar Sahib.
Ujjwal
51. Recovery of 3 mobile sets with SIM card.
एक second, just a moment. 3 mobile,
4 SIM,
4 SIM,
1 motorcycle.
1 motorcycle. मोटरसाइकिल का ये साइबर क्राइम से क्या लेना देना?
वो साथ में प्लेस ऑफ ऑफेंस पे थे ना, वो साइबर क्राइम में सब साथ।
ठीक है। एंटीसीडेंट बताइए।
नो एंटीसीडेंट।
क्राइम लिंक।
नो क्राइम लिंक। विक्टिम है 30,917।
विक्टिम, one victim,
30,917।
custody since 18.
Same.
The learned counsel for the petitioner submits that he is in custody since 18/3/26. ये same order ही बना है, identical. इसमें 3 mobile, 4 SIMs standing in the name of different persons, along with 1 motorcycle has been recovered. 1 victim has been identified. ठीक है? चार्ज शीट सेम देना होंगे आपको. Next बताइए.
53. 52 Rajkishore Sahib.
राजकिशोर साहिब. इनका क्या स्टोरी है?
1 mobile set with 2 SIM cards.
Just a moment. 1 mobile, 2 SIM.
Same custody with
Okay.
2 antecedents, but in these cases there is a case of 379 theft of electricity. In that these 2 cases he has already been acquitted. I have the order.
Acquitted?
Yes. समाप्त हो
Both the
चुका है.
cases are under electricity.
Yes. No case of criminal nature. समाप्त हो चुका है.
दो केस एक साथ समाप्त हो गए.
समाप्त हो गया तो पुराना केस.
बिजली चोरी का केस.
बिजली चोरी. Yes.
Not a cyber case.
No.
What the learned counsel stated on behalf of the parties. Counsel for the petitioner submits that 1 mobile, 2 SIM standing in the name of other person has been recovered from the person. Is alleged to have been recovered from the possession of the petitioner. He has 2 criminal antecedents, but none under cyber offense. And in those criminal antecedents, in those criminal cases, he has already been acquitted. They are relating to offense under the Electricity Act. He is in custody since 18/3/26, and charge sheet has been submitted on 15/6/26. Victim? Any victim?
No victim.
But in the there is no victim has been identified so far as the petition is concerned. Two co-accused persons have been enlarged on bail, being in PA number 4972 of 26 and 4702 of 26. These same details. The learned counsel for the state has opposed the prayer for bail, but the aforesaid submissions made by the counsel for the petitioner is not in dispute. बस bail कर दीजिए इनका, okay ना? आप बताइए next. Amit Kumar Shah.
Amit Kumar Shahi. There's a recovery of one mobile set with one SIM card, and the SIM card is registered in the name of his father.
One mobile,
With one SIM card,
one SIM.
which is registered in the name of his father.
Both the mobile and SIM both.
Yes. And no antecedent. Custody same 18/3/26.
Victim.
No victim.
No victim.
No victim.
तो चार्जशीट कैसे हो जाएगा?
इसका अमित कुमार का ही मैटर, अमित कुमार का है।
चार्जशीट तो 90 दिन पहले करना ही।
मतलब चार्जशीट करना ही ऐसा कुछ है?
अदर एविडेंसेस है।
No victim.
The learned counsel for the parties are present. The counsel for the petitioner submits that petitioner having no criminal antecedent is in custody since 18/3/2026. One mobile and one SIM is alleged to have been recovered from the possession of the petitioner, and SIM was standing in the name of his father. Charge sheet has already been submitted on 15/6/2026. Co-accused have been enlarged on bail. बहुत detail दे देंगे सिर्फ. Counsel for the state though has opposed a prayer for bail, but does not dispute the official submissions made by the learned counsel for the petitioner. Okay. Yeah, ले लीजिए वापस. और ये दोनों बेल ऑर्डर उनको दे दीजिए. केस डायरी आपका है, इनको वापस करें. Case diary submitted to this court is returned back to the court का है.
कोर्ट का
अच्छा ठीक.
from supplementary list. Do we mention case item 1, first appeal 31 of 1025?
बाकी जो
बाकी
बचा
तो
है
tomorrow.
सब
Last order में first
the matter has been listed at the instance of the office. It has been pointed out that in the order dated 17/7/2026, the case number and in the first line, the case number has been inadvertently mentioned as first appeal number 31 of 2025 instead of first appeal number 32 of 25. Reduce the records. The order dated 17/6/26 is hereby modified. The case number mentioned in first line of the order is modified and is directed to be read as first appeal number 32 of 2025 instead of first appeal number 31 of 2025. The office is directed to carry out necessary correction. The special messenger cost, which has already been deposited, is directed to be processed further.
For final disposal item 3, first appeal 62 of 1025.
Notes have already been filed.
बहस करना होगी बस.
Notes have already been. The first portion of the note, that facts and what was treated in the written statement was with the exhibits, issues that have been mentioned, and then what is the finding of the trial court. And the second portion of the note consists of the point for determination, which is proposed in page 12 of my note.
Please read the last order which I.
Can I start with the judgment itself?
Yes, you can start with the judgment. You have to
But
look at
if
this.
this would have been taken up, the note, then it would have been easy,
Okay,
because
start with the note.
it contains a list of date.
You have also filed your submissions.
It contains list
Yes,
of date that would,
And if there is any mismatch while he is placing his written submissions, you please let me know. Yes, please, continue.
in page 7 and 8, the chain of title have been mentioned.
The suit was filed for declaration of title
Yes,
and
for confirmation of possession.
all the chain of title is given in.
It is chronological list of date is given in page 7.
Page 7. Yes.
Yes, and in page 8, the chain of title of both the parties, which they are, this is the rival chain of title which the parties are claiming. So mine is that the originally, if page 8 may kindly be seen,
Please, and
originally the property was recorded in the name of Rajmanti Kumar. She was the landlord of the property, and it was a Bakas land in CS Nabyan. The properties were recorded in the name of Rajivanti Kumar and others. Rajvanti Kumar, by registered deed, transfers the
you are
property.
reading page 8.
Pardon?
Page 8.
Page 8 of my notes.
It is at page 7, 2010-1910. CS chronology of list of dates and events.
When you say,
कोई chronology.
it seems that
कोई बात नहीं, आप पेज ऊपर नीचे हो जाए.
then the first sale deed is 22/8/1921, and this was a registered deed by which Rajvanti Kumar transfers the property in favor of Praful Kumar Ghosh, which includes the suit property. Total area that was there in the sale deed was 15.40 acres. In this particular sale deed, which includes the suit property. Suit property is only 1 acre. Then thereafter, there was a partition amongst the family members of Praful Kumar Ghosh, between Praful Kumar Ghosh and his other 3 brothers, and all were sons of Kalipada Ghosh. So amongst all the sons of Kalipada Ghosh, that is Praful Kumar Ghosh and his brothers, there was a partition, and with that partition, the suit property was allotted to the share of this Sanat Kumar. This is also one of the reasons that has been assigned by the trial court as to how the property was transferred. It was clear from the partition deed that the property was allotted to Sanat Kumar Ghosh, who was the brother of the original transferee. Then Sanat Kumar Ghosh had 2 sons, Ajit and Ranjit Ghosh. And then Ajit Ghosh died leaving behind Mahua Mitra, and the other son Ranjit Ghosh died leaving behind Sanjay Ghosh. And they both have executed a registered deed in the on 23/5/2016 in favor of the plaintiff.
But this is not reflecting that his sons were Ajit and Ranjit in this sequence.
The 2 sons of Sanat Kumar Ghosh were Ajit and Ranjit. Ajit had 1 daughter, Mahua Mitra, And this second one, that means Ranjit had a son named Sanjay. Now that means that grandson and granddaughter of Sanat Kumar Ghosh, they execute a sale deed with regard to the suit property on 23/5/2016,
Yes.
and then certain claims were raised by the defendant, then the suit was filed. This was the reason. Now, the defendant's chain of title may kindly be seen. Now, they claim on the basis of a registered deed of sale executed by one Rajkumar Mishra. That is the only claim, and that is in the year 1958. This is for the first time
Raj Kishore
Raj Kishore
sold
Mishra.
to Mahadev Rao.
Yes, he sold it to Mahadev Rao. This
On that day, when the sale deed was executed, did he have any title?
no, that is the reason that we say that nothing was left with the family of the landlord, and Rajkishore Mishra, he transfers the property to Mahadev Rao, and then Mahadev Rao in the year 1958, and thereafter Mahadev Rao transferred the property to the defendant number 1 hearing in the year 1985. So,
You need to respond to this. Yes.
so this is the chain of title. So basic contention is that here the interpretation of section 48 of the Transfer of Property Act would come into play, that whoever, when the same person had already, the landlord family had already transferred the entire property, which included the sold property, then nothing was left with the landlord's family.
How is Rajmanti related to Raj Kishore Mishra?
This the trial court has said that it has said with regard to us that we have failed to establish that as to how he was connected with the family. But
You are the defendant or you are the plaintiff?
I'm the plaintiff.
You are the plaintiff.
I'm
So,
the person who is claiming on the basis of a sale deed
Recorded
executed by recorded land.
the recorded landlord is Rajwanti Kumar
Yes.
and not Raj Kishore Mishra.
No. So this particular
This
fact
CS
is
Khatian is this fact is evident.
yes in CS Kalyan it is.
In the CS Katyan name of Rajwanti Kumar is
But the trial court has cast this, was shifted the onus upon us to establish that we have failed to establish that how he was connected with the original family. This was not for us to establish.
How who
Because-
was connected? Raj Kishore Mishra. Mishra was connected to the
Rajkishore Mishra has
You
executed
claim,
a
isn't it?
My lord, I claim that I purchased from Rajkishore Mishra and this question was not answered in the first one.
it was for them to, the defendants to have established as to how
Not
they were.
only the establishment of relationship, but also how did he acquire the title?
Yes,
Both the
exactly,
things.
exactly.
Just pause for a minute. Yes, how do you fill up this gap?
My lord, in the judgment as well as the documents filed before the court, there is nothing which says that Rajkishore Mishra was how he was connected to the original land deed
Or to the land?
or to the land. It is not there.
So
And
he
in
never
our-
had any title. So you are claiming through Raj Kishore Mishra,
My lord,
but you have not been able to establish his title. Then still why the court has not decreed the suit in spite of that? What is the reason for judgment in your favor?
my lord, the reason for judgment in my favor is that the defendants in the suit were tribals, and therefore the burden has been cast upon the plaintiffs to prove the case as to how Rajkishore Mishra was connected and to the land or the landowner. And on that basis, the judgment has been passed.
See, Raj Kishore Mishra has nothing to do. The property has been sold in 1969. It is not a case that the land is otherwise recorded in the name of any ST.
But pursuant to the transfer, the Mahadev Munda
Yes, Mahadev Rao.
Mahadev Rao came in the possession and he sold the land to Victor Mitch, that is father of
Whose
Deputy
possession has been found?
My lord,
Who is in possession of the property?
rent was fixed in
They
the
are
name
in
of
possession, and only thing is there that in 1985 after the sale deed, their name was mutated, but there was no mutation of the original Rajkishore Misir or even the Mahadev Rao. There was no mutation whatsoever. Only thing is there that
Do you
mutation
claim
is there.
possession?
My lord, I claim possession by virtue of the rent fixation of the year 1986, because it is reflecting the name of Victor Mitch, who is the second purchase, who is the father of
But was it ever mutated in the name of vendor? That is vendor of Victor means Mahadev Rao?
that is not.
And in cross-examination, they have admitted our possession. That has not been relied by the trial court on the ground that they are members of schedule. That was one of the issues which had come up in the last.
हमको याद आ गया.
हाँ, वही, इसलिए थोड़ा सा refresh होना था. So two things have gone against me. One was the trial court found that my deed of 2016 was registered in Calcutta. This was the reason for calling for the records from the trial. This was
not correct.
No, incorrect, absolutely incorrect. What was the fact was that the power of attorney on the basis of which
That
the
was
sale-
registered.
Yes, that was registered in Calcutta, not the sale deed. Sale deed was registered in Ranchi. So that has been mistaken finding by the trial court that the sale deed itself was registered in Calcutta.
आपने अपने oral evidences भी discuss किए.
हाँ, Sarah. Well, that is there. 3 points for determination. If the honorable court would come to points for
आपने
determination.
fresh file किया है क्या? Written submissions पहले भी शायद कुछ file
पहले हम फाइल किए थे, लगता है वही वाला है.
ये strike off क्यों किया?
क्या?
Visual survey land details of Prafulya Chand Kumar Ghosh.
क्या?
Then he is क्यों हम strike off किए? So details. हमको लग रहा है कि इसका हम जजमेंट लिखाना भी शुरू कर.
Partially it was, and then
वो साथ साथ लिखाते हैं. जब hearing चलता है ना,
हाँ,
तो साथ साथ काम चलता है. जजमेंट का काम साथ साथ चलता है.
हाँ.
तो इसीलिए लगता है कि इसमें से कुछ लिए होंगे.
नहीं, ये only reason was that because it was noted that my deed is registered in Calcutta, that was the reason that it was stopped. There was some confusion with regard.
So you have suggested the points for determination, right?
Yes. There are three. Whether the plaintiff appellant has been able to prove his right title, interest and possession of the leasehold property. Whether the defendant respondent acquired the right title, interest and possession on the basis of successive registered deeds.
Where is that point for determination?
This I am forwarding.
This is that.
Yeah,
This is that page number
this
12.
is the fresh I have
Page number
prepared and
अच्छा,
final.
fresh.
This is the final. And I have also separately I have dealt with each of the.
यही same चीज है मेरे पास.
अच्छा.
Same. इसका आपने सॉफ्ट कॉपी दिया है ना? आपने भी दिया है ना?
नहीं, मैंने तो हार्ड कॉपी दी है.
तो सॉफ्ट कॉपी दे दीजिए ना. हम लोग कितना टाइप करवाएंगे और करेंगे. ठीक है, आपने दिया है सॉफ्ट कॉपी. आप दे दीजिए भाई सॉफ्ट कॉपी.
And the third point is, this was also important, whether the plaintiff or defendant number 1 is in possession of the zone.
That's right.
And I have dealt with each of the witnesses in point number 3 as to how each witness has stated what which PW has plaintiff witness has stated with regard to possession in which paragraph, and even the defendant's admission also, that has been mentioned.
Primarily, you are basing your case on the basis of title of Raj Kishore and the mutation.
Right.
That's all.
And trial court has relied on that admission. It has discarded the admission on by the member of scheduled tribe, saying that they have colluded and all those findings. They have not even been raised by any of the parties, or even the deputy commissioner did not raise. So the trial court could not have, on its own, could not have made out a case which was not there. Because otherwise, whatever admission is there, it is binding on the party. Even if he is a member of scheduled tribe, that is also binding. So, as it was
Unless
stated,
the court calls for a
yes, and this
calls
has
for
to be,
for them to
yes,
need evidence on it.
and it has to be done. This power has to be exercised at the trial itself,
That's
where they have admitted, and the court says that no, despite their admission, you have to need evidence to prove. That recourse has not been taken, and then simply at the final judgment it discards the evidence. And it was, as it was taken note by the Honorable Court on the last occasion, that this was not a case
आपकी
of,
तरफ से बहुत serious contest नहीं. Are you seriously contesting?
The manner in which it has been dealt in before the trial court makes me helpless, because there is nothing on my part that I can bring
I
before.
appreciate that, but I just wanted to know, is there any inhibition on your part to argue? या मान लीजिए कुछ हम आपको ठीक से समझ नहीं पा रहे हैं, लेकिन ऐसा कोई जैसे normally second appeal इतना contested, first appeal इतना contested
These
होता
are the only thing that are there.
जो record में है सो है, you can't help it.
That is there.
State is also there. State. Are you there for the state in this case? What do you have to say? Sorry, you don't have the file. देखिए अभी जो आपके एज ही है वो तो हार्डकोर सिविल प्रैक्टिशनर हैं, तो उनको तो बहुत अजीब लगेगा कि हमारे काउंसिल्स के पास सिविल मैटर्स का फाइल नहीं, and they are standing like just like that. Next occasion, तो इसको डिजर्व करना अपने पेरेंट्स से, तो चलिए डिजर्व. The arguments concluded, judgment is reserved.
Orders item 4, Constable 427
वो
of
सॉफ्ट
180.
कॉपी देंगे आप
हाँ,
भी देंगे सॉफ्ट कॉपी आप फॉरवर्ड करें इसका कर दीजिएगा सॉफ्ट कॉपी. यस
Item 4.
ये तो फाइल से मोटा ऑर्डर शीट हो गया, क्या करें हम इसको? Are you there in this case? Are you there in this case?
on application has been 1631 seeking modification. This now reverse here.
defendants have filed an IA for modification of order.
Yes. What do you have to say?
But we don't have an objection because on earlier date the name had already been deleted. That is annexure 2 of the IA. Para 6 may be seen of the order.
Annexure 2 of the IA. There is no annexure 2. There is no annexure 2 to the IA.
Order dated 11/1/23.
11/1.
23. Order number 21.
Just order number.
21.
हाँ, बताइए क्या है इसमें?
In that para 6.
You have filed the IA?
Yes, I
For what purpose have you
For
filed?
modification of order dated by 31/10/2025.
So what do you want to say?
The respondent number 8 is already been deleted by the wide order dated annexure 2. 11/1/2023, and it was our mistake that we could not inform that day on.
So the subsequent order is only to be recalled. Which order is required to be recalled?
31. Order number 36.
You say that the name of the wife is to be incorporated.
Lordship, that is another IA. That is intervener application.
That is interview. She is also referring to respond number 8 only.
Lordship, that was detected when this order was passed. She is the wife of respondent number 1.
This is of my board.
No, Lordship.
Okay, so it has come only for the modification of an order.
IA number 1631.
1631 for amendment of substitution of parties.
That's for modification of
1631. Abate हो गया था.
Yes,
Already substituted.
Deleted.
deleted.
Her name was deleted.
Her name was deleted. But she was already, her name was earlier deleted.
Earlier deleted.
Okay, IA number 1631 of 26. The learned counsel for the parties are present. This matter has been placed before this bench for for passing appropriate order in IA number 1631 of 26, seeking modification of order dated 31/10/2025, passed by this bench. The learned counsel submits that on 31/10/25, it could not be pointed out that the respondent number 8 has already been deleted by court's order dated 11/1/2023, and therefore the order dated 31/10/25 recording that the proceeding has abated in connection with respondent number 8 is required to be modified. The counsel for the respondents has no objection to the prayer for modification. After hearing the learned counsel for the parties, the order dated 31/10/25. To the extent it records that it records that respondent number, to the extent it relates to respondent number 8 in paragraph 7 of the order is hereby modified, and the paragraph 7 of the order dated 31/10/25 is directed to be deleted. Ho jayega deletion. Office is directed to carry out necessary correction in order dated 31/10/25. Post this case before appropriate bench as proposed.
Item 5, first appeal 125 of 2026.
The last date leadership had directed to file a supplementary in order to annex the death certificate and the legal heirs which are to be substituted.
Not if they have died prior to passing of the judgment,
judgment.
therefore it is a nullity also.
They have died prior to passing of the judgment.
Judgment,
Yes,
yes,
yes.
much prior to.
The death certificate is annexed as annexure S by 1 lots. That is dated. Date of death is 30/6/2021.
Yes. Date of death of respondent number
5.
and respondent number 4 has also expired.
So 4 I filed total as number for on behalf of 1 to 4.
It is respectfully submitted that respondent number 4, namely Sabita Khatun, died on 30/6/2020.
That is respondent number 5.
Respondent number 4 ही लिखा हुआ है. Supplementary affidavit on behalf of respondent number 1.
That is my typographical mistake.
Sabita Khatun is respondent number
5 in the first.
and who are you? It has been filed through this affidavit. Who has sworn this affidavit?
This one respondent number 1.
How is he related to respondent number 4?
He has informed that he is the brother of the brother-in-law.
यहाँ पे तो respondent number 5 is Sabita Khatun,
Sabita.
wife of Abbas Ali.
Yes.
Did she file any written statement? And the reference has been allowed. Who were the objectors before the
We were the objectors.
तब क्या करें? Are you for the state?
No, I am for the
अच्छा, for the
private
private.
respondents.
So it is a nullity.
That is true. That is what I also came to know after I received the death certificate. It have to be remanded to the.
The award was prepared in whose name?
What has been prepared in the dead person?
Including Sabja Khatun.
Subject.
So you were seeking enhancement.
No, sir, you are against enhancement.
You are the CJM, CCL.
UCC.
See, if you set aside that, then you go and fight it out again. That's the only thing.
Also, there is one delay also. IE for conservation.
Delay in filing the appeal. इनके लीगल ईयर्स का नाम दिया है?
हाँ, only one son is there. ये शिप आधार कार्ड उनका SY2 में लगा हुआ.
अब तो आपको लीगल ईयर भी पता चल. डिले भी क्यों करना है? तो ऐसी नलिटी है तो क्या ही करना है?
Demand back.
The learned counsel for the parties are present. A supplementary affidavit has been filed by respondent number 1, placing on record the death certificate of Sabita Khatun, respondent number 5, who is said to have expired on 30/6/2021. And it has been also submitted that she left behind only one son, namely Mumtaza Ali, Mumtaz Ali, whose details have also been placed on record by placing his Aadhaar. The learned counsel for the respondents has submitted that by the improved judgment, the compensation has been enhanced. To this, the counsel for the appellant has submitted that but अजीब नहीं है. You were the applicants and you only did not file the substitution petition. You never brought it to the notice of the court.
It was the
So-
duty. It was the duty.
So you will take advantage of your own wrong. Yes, Mr. Gupta, just tell us. Mr. Rahul Gupta, you just tell us. The applicant in land acquisition proceedings, so one of them died. They did not bring it to the notice of the court that they have died. So it becomes a nullity.
No, because this would be covered by one similar matter had gone up to the Supreme Court.
ऐसे तो nullity है. How does it become a nullity? तब तो बहुत अच्छा है. अपनी गलतियों का अपनी गलती करिए उसके बाद बुनी nullity. There is one judgment on this. क्या बोला है?
Para-10. So, please interest.
There is on 5 judges bench relating to if they were substantially represented, that was the word used. So I'll just point it out here.
They
Because
must
this
be,
issue would is regularly coming up. So I'll pray
In
that.
one case, I have held that if they are substantially represented, but the point is that this lady, her rights, is she substantially represented by her brothers? Her right is substantially represented by her brothers. Must be, because they are on the same boat. They are claiming the same thing.
Same family also.
इसका record है, दिखाई दो.
Ultimately, inter se right between the parties are not being decided with regard to that particular section.
Yes.
Had it been so, then the matter would be.
There is no conflict amongst them. ये एक राशिद अंसारी है ना इसमें,
हाँ वो अलग फर्स्ट अपील में
वो अलग फर्स्ट
127 of 2026
ये दूसरा है
ये 125
125 का रिकॉर्ड कीजिए. अलग से कोई रिकॉर्ड नहीं है इसमें. राशि क्या नाम है जिनका डेथ हुआ है?
सब्जा खातून
हाँ सब्जा का. She does not belong to the same family. Subject Khatun. Do they belong to the same family? Do you have any idea?
I was informed because the son came along with the 4 respondents. So they said that they are the same. I was informed by them. It's not like I'm aware of.
Subject Khatun has expired prior to passing of the impugned judgment. However, the learned counsel for the appeal parties are directed to address this court as to whether her interest was substantially represented by the other respondents in the case. For that purpose, let notice be issued through the concerned police station to the son of Subject Khatun. He will also come and address. Namely, Abba Mohammed
Mumtaz Ali,
Mumtaz Ali, son of
Abbas.
Abbas Ali, opposite to Masjid, क्या है? ड्रमर बेड़ा,
Near Masjid Tumar Bera.
डूमर बेड़ा, सालबेड़ा, रामगढ़, झारखंड। ये एड्रेस है, यहाँ से पेज नंबर 4, लास्ट एफिडेविट का पेज नंबर 4 में मिलेगा, राइट? आने दीजिए, देखते हैं।
On 5 judges bench with regard to this issue, land acquisition, what would be the effect of them? And given another case also, this is 2003 volume 3 SCC,
2003 volume 3 SCC
272,
270.
Sardar Amarjit Singh Garg.
In the light of the judgment passed by the Honorable Supreme Court reported in bracket 2003 bracket close 3 SCC 272. ठीक है? थोड़ा देख लीजिए judgment.
Even the latest judgment, that is something, of course, that is 2 judges, but that is the latest judgment.
I'll go through it. है ना? A judgment of the Honorable Supreme Court in arising out of special leave petition within bracket civil bracket close number 9947 of 2024 has also been placed by the Learned Counsel for the applicant, which is dated 6th of November 2025. Next week रखते हैं। ऐसे set aside करके क्या हो?
तो बहुत matter
Unnecessary
और
है।
necessary lengthy हो जाएगा।
Nothing, उनको तो substitute वहाँ पे करना ही पड़ेगा।
कहाँ पर?
Lower court में।
इसीलिए उनको नोटिस किया है ना। देखते हैं अगर मान लीजिए सब्सटैंशियली रिप्रेजेंटेड है तो उनको उनके लिए आप एडिशन ऑफ पार्टी फाइल करके कैन प्रोसीड, इतना ही तो है, क्योंकि दे आर ऑन द सेम बोट, एक ही चीज फाइल किए हैं, ठीक है, एंड द जजमेंट इज इन देयर फेवर, तो उनको क्या दिक्कत होना चाहिए। और बाकी सारे केसेस कहाँ हैं?
सब्स्टिट्यूशन के सारे केसेस जो लीडरशिप नाम रखे थे और बाकी सारे केसेस 21 जुलाई
जस्ट राइट, इसका और सेकंड केस का
They have
सब्स्टिट्यूशन में
no, they have not filed the supplement.
Second में हम
फाइल नहीं किया सप्लीमेंट्री
What
एफिडेविट।
happened in yourself directly filed the supplementary affidavit along with the wakalatnama. But the son was working outside. They said they are coming today.
तो कल रख दे,
They are coming to 1 week, next week. So I'll file everything. Only 1 week.
दोनों केस,
Yes.
both the cases, both the cases are so that ये हुआ 1st April 125 और 26 में। For rest of the two cases at the request of the counsel for the appellant for the respondents pose his case next week। तो ये सारे matters हम लोग Wednesday को रखते
Yes.
next Wednesday in supplementary causes।
Can I get copy, soft copy of the incident?
हाँ, it is your right, आ गया होगा हम लोग के पास ना, पूछने की कोई जरूरत ही नहीं है, स्कैनिंग हम सबके लिए होता है, you just get your pen drive and take the LCR। पुराने रिकॉर्ड्स का स्कैन नहीं करता, you can also, आप भी ले लीजिए।
From daily list for hearing item 1, first appeal 194 of 2025.
The preliminary objection in this matter others. The state of Bihar has been made party in this matter. The matter relates to Kodarma. Original suit, it was filed in the year 1995. The order was passed in 2025. Balance the parties are Kodarma, balance the state of Bihar through Deputy Commissioner Kodarma. The Bihar State Rural Development Corporation, Bihar Ranchi, a body corporate is constituted under section branch Dhuri Tilaiya. That's how the Bihar will balance come into picture. After separation, it is now Jharkhand.
Nature of order क्या है?
Nature of order. My money suit, I had filed a money suit which has been rejected by the It was, this money suit was filed pursuant to direction by the Honorable Division Bench of Patna.
What was the claim amount?
Claim amount was, this matter would
17 lakhs.
yes, actually 80% of the matter would be covered by one order passed by this Honorable Court in the year 1994. Division bench order that actually that 80% of that would be covered.
No, the point is, he is raising an objection that state of Bihar is a party. The point, whenever the case was pending before the court, did you file any petition to deletion of name or substitution of name? Suppose a liability is fixed, then there will be an issue who will pay. The matter is not going to end. In a case of money suit, ultimately the money has to come from where is an important issue. Then did they file their written
No.
statement?
Yes,
You filed your written statement.
No,
So at best you
they
can
had filed. They had filed. The state was state of Bihar was defendant number 1, and defendant number 2. They had filed one single written statement, and defendant number 3 was Bihar State Mineral Development Corporation.
they did
So
not.
they had also filed a separate written statement. So 2 sets of written statement were filed.
Lords, I am not aware of the fact that whether it was filed before separation of the state or
It must have been filed 95 का suit.
after.
तो ये अल्टीमेटली मान लीजिए डिग्री हो जाता है तो फिर स्टेट ऑफ झारखंड बोलेगा मेरा लायबिलिटी नहीं है, तो ऐसे हम डिलीट नहीं कर सकते. आप पिटीशन फाइल करिए. I will not delete it like that.
Lords, they have made me the party. Lords, but the cause of action is Kodarma.
Wherever be the cause of action.
Deputy Commissioner Kodarma is not Malad Bihar.
देखिए आपके ये ओरल सबमिशन से ना ये हम डिलीट नहीं.
Malad 75.
You file your petition, let them respond.
Malads.
There is a suppose a money decree is passed, then there would be a point as to who will pay the amount, whether the state of Bihar will pay the amount or the state of Jharkhand will pay the amount. Then there can be an interstate dispute. We do not know. If you want to make, it is one thing to say you want them to be deleted completely, and it is another thing to say that you want the state of Jharkhand also to be added as a party in this case. Maybe the successor state, maybe by virtue of succession, but something has to be done about it. Without petition, I will not delete it. Like
Yes, Malad, my understanding is that Malad, it is deemed Malad that once the state is bifurcated, and Malad, the cause of action is Kodarma, then Malad, state of Jharkhand.
cause of action is Kodarma,
Malad.
but the liability will come from the coffer of the state.
Malad, state of Bihar means the state of Jharkhand. Malad, I will file the.
You have to file an affidavit to the
Malad,
subject.
Malad, in other cases, every day I Malad contest and it is said Malad that no, you state of Bihar cannot pass the order against the authority of state of Jharkhand because Malad such and such. So every day we are facing this.
आप मिट में ना ये सिविल में ऐसा नहीं चलता.
सिविल में ये डिसमिस मैटर है, इसमें ये आए हैं और बिहार को पार्टी सीधा बनाए. हम
ये सीधा नहीं, सूट में पार्टी है, इसीलिए यहाँ पे पार्टी है. अगर आपको पार्टी नहीं बनाते तो ऑफिस डिफेक्ट लग जाता. सूट में if somebody is a party, you find your.
जैसे क्रिमिनल अपील है 1994 का, उसमें नाम झारखंड लिखा जाता है.
देखिए ऐसा है ना, क्रिमिनल अपील और सिविल में बड़ा फर्क है.
हुजूर हम रिप्लाई
दोनों में बहुत फर्क है. इसको आप थोड़ा बिहार भी ऑर्गेनाइजेशन एक्ट अरेंजमेंट्स ये सब थोड़ा देख के फाइल करो. इतना आसानी से हम ऑर्डर नहीं करेंगे.
नहीं ठीक है.
और उसमें अगर मान लीजिए आपको लग रहा है स्टेट ऑफ बिहार हैज टू प्रोसीड, then you should make state of Jharkhand has to proceed. Then you should we will also ask the advocate general to address on this. ऐसे नहीं होगा. डिक्री में जो कॉमा फुल स्टॉप भी रहता है ना, उस पर भी डिफेक्ट लगता है. In all civil matters, it is like this. Mr. S.P. Roy, a counsel appearing on behalf of the state of Bihar, has submitted that now the state of Bihar has no role to play. However, the suit was filed in the year 1995, making the state of Bihar and the authorities thereunder as defendants, and the suit was filed seeking a money victory. This court is not inclined to delete the name of state of Bihar and its authorities on oral submissions. To this, counsel for the state of Bihar submits that we shall file appropriate petition.
Sometimes
How much time do you need?
4 weeks.
Post on 29 July.
For final disposal item 2, first appeal 216 of 2023.
There is one idea pending. Okay. So what is the matter?
Matter is matter the suit for declaration was the appellant before a lordship was the pending.
Suit has been dismissed.
Suit had been dismissed. And surprisingly, the lordship of kindly see the relief which I have sought for in the suit, paragraph 3 of the improved order judgment, page 16 of the brief, or internal page 4 of the judgment. The players relief has been quoted. May I read it?
Yes, I
Yes.
there in the degree.
I will, that the adjudication plaintiffs, that on adjudication, plaintiffs' right, title, interest be declared over the same property and their possession be confirmed. B, that it be further declared that defendants have no right whatsoever any part of the same property. C, that the permanent injunction the defendant, their main agent, servant be restrained from going on to same property or from in any manner or otherwise interfering with the possession of the plaintiff of the same property or over any portion of it. D, the interim injunction be granted in terms of relief C, above, that if defendant forcibly acquired the land in such case, but compensation of 20 lakhs be awarded to the plaintiff within 15% interest with realization of the amount, cost and other costs. Now, the lordship can see the next page, page 5 of the judgment, the detail of the land will be given. Schedule A of the grant has been quoted. I think I am referring from the judgment. Lordship is in the decree as well.
I'm there in the judgment.
Yes. Page internal page 5, running page 17. Now, look, there are two plots. Khata number 36 and area of 5.35 acres. Now, the funding of the court after the paragraph 6 on the basis of pleading of both the parties, following issues have been settled by the court. 1 to 7 issues were framed. Thereafter, in support, oral and documentary evidences were produced by on behalf of the plaintiffs. Now, your lordship, I am just giving a summary so that thereafter we move. There are 9 your lordship. In support of the case, defendant has neither produced any witnesses nor produced any documentary evidences. There are 10. There is a discussion of the cases, and the finding is on page, last page, is running in internal page 9. The section 20, capital A of a specific daily fact has been quoted by the court, which shows that this court has no jurisdiction to entertain the very suit so brought by the plaintiffs for their relief or relief so sought by them in the claim, nor it is necessary to decide other issue so settled in this suit after discussing the evidences either oral or documentary so got by the parties concerned regarding this case. Accordingly, suit and the same filed 1926.
There is no injunction will be granted.
No injunction can be granted.
Okay, no injunction, but rest of the cases,
That is
rest
my
title
support
suit
for-
etc. was required to be decided on merits.
That judgment is there, my lord. Order 20 rule 4 says what is the judgment? The judgment must contain the concise finding on each of the issues. And once the parties frame the issue, the court,
The property has been acquired.
no, that is my relief also. अगर आप फोर्सली acquire करते हो तो compensation
Kौन है
दीजिए.
इसमें respondent? Yes, you are there.
Power grid is being agreed on that. And para 10 medicine.
No, the property has been acquired.
There is no.
There is no acquisition.
There is no acquisition.
तो infrastructure project कहाँ से आ गया?
This is the government land lot.
गैर मंजूर land, they have taken this
अरे
land.
गैर मजूरवा लैंड अलग बात है, लेकिन जजमेंट क्या हुआ है?
Very adjudication.
No injunction shall be granted by a court.
I am already in possession. There is no
Not a
question.
single rent receipt has been on that one.
The court has not decided any of the issues. Why? आपका जमीन है तो आप रिटन स्टेटमेंट भी नहीं फाइल करेंगे. रिटन स्टेटमेंट
They
फाइल
have
किया?
They have filed.
Surprisingly, they have filed EWS and section 20 capital A of the schemes relief was the one of the ground for their rejection of claim. The court has
Paragraph
so that
talks about this.
just for one moment, if your lordship may kindly have the specific relief act. I have the copy, my lord, your lordship may kindly see. Section 20 capital A was introduced in 10th of August 2018. 10th of August 2018. Yes, sorry. 1st of October 2018. Please.
You see, no injunction will be granted. Does it say that no suit will be maintainable?
Sir,
Okay, injunction will not be granted, but suit will be decided.
This part is not.
And suppose ultimately it comes that they are the owners of the property, they are the title holders, appropriate compensation will be given to them. What is the purpose of this particular section? That no infrastructure project should be stalled by virtue of any kind of injunction.
By the
Injunction
courts.
will not be granted. Simple.
They claim to establish that it is their land.
That is, where is the finding?
Where is the
We are
finding?
sitting in first appeal.
Where is your adjudication?
Sir, अब तो evidence आपका आ गया.
सर एक चीज और
एक second.
हाँ ठीक है सब कुछ आ
We
गया
are in first appeal.
yes
Continuation of suit.
yes
Why should we remand the matter?
no your lordship will decide
Sure, we will decide.
these
सारा आपका evidence है, ठीक है?
हाँ ये चाहे तो कर सकते हैं केवल एक
ये
चीज
जज के चाहने की बात नहीं है, हम ऐसे डिमांड नहीं करेंगे. इस तरह से
नहीं
डिमांड नहीं करते.
हम तो चाहते हैं डिसाइड हो जाए
हाँ तो बस डिसाइड हो जाए तो आप अपना केस प्लेस करें.
ठीक
They have filed a witness statement, but no documents were introduced.
कोई बात नहीं, अभी तो इन्हीं का केस चलेगा. प्लेन दिखाइए अपना और क्या क्या डॉक्यूमेंट रिलीज किए. What was the cause of action?
cause of action I have stated
You are in possession.
I
You
am-
claim title.
yes
What is the cause of action?
cause of action that they started construction of that power substation over the some area of land which contains my land also 20 acres. We are not concerned. We are only concerned with 5.35. So I requested that you demarcate, and if this plot is outside of your purview, you will leave it. But they have not done anything. Rather, they have started construction. They have constructed, and the moment we came to know, we replied, done all recourses before the authority, and then we finally sued. Therefore, cause of action is very much on the
The
date.
property is recorded in whose name?
That was 1943 second Hukumnama by
Sada
the ex-landlord, Sada Hukumnama by the ex-landlord, and possession was delivered. The exhibits were there.
Which all exhibits are there?
Exhibit 7 is the Hukumnama.
उसके बाद
उसके बाद रिसीट है
कब का और किसका?
ओरिजिनल लैंडलॉर्ड का
There is finding that they have no land receipt.
साइड बाय साइड करोगे दिखा देते हैं।
वहां तो कोई गवाही प्रोड्यूस नहीं की, यहाँ पे आपको इतना दूसरे कोर्ट में जाना है क्या? यू हैव टू गो टू अनदर कोर्ट। हाँ तो बस शांति से सुनने दीजिए, अपीलांट अपने परेशान। Which is that exhibit?
Exhibit X and Exhibit 7, both are the same.
Exhibit Exhibit X तो mark for identification।
और Exhibit 7 जो है मेरा हुक्मनामा है।
Exhibit X क्या है?
वही
तो
हुक्मनामा।
exhibit ही नहीं हुआ ना।
Exhibit 7 हुआ ना एक बार।
नहीं, आप हमको बताइए आपका जमींदारी रेंट रिसीट कहाँ है और वेस्टिंग में आपके नाम से म्यूटेशन हुआ क्यों? ये दो चीज आप हमको दिखाइए।
That is exhibit 1/1, which is rent receipt. Exhibit 1/1 is rent receipt granted by the ex-landlord of 1943. And thereafter some proceeding were initiated in the court of Jamabandi was opened, appeal was preferred by the state, that was dismissed. That is exhibit exhibit 2 was the order of dismissal, Jamabandi opened. Thereafter, appeal exhibit 2/2 by preferred by the state, which was dismissed at Jamabandi. And all the exhibits were marked on no objection. So subsequently, they cannot take and say unless they produce in the court certain contrary or objected that
Then
exhibits.
thereafter upon filing of returns by the zamindar,
Yes,
the land should have been recorded in your name on at the time of vesting.
that was.
What happened?
That therefore exhibit 2/1 and 2/2.
You see, you have zamindari rent receipt. There are two rent receipts.
Yes,
One is of 2943.
42,
Another one is of
29, it is
9448.
4.
What is the date of hukumnama?
Hukamnama is dated 99 Sambat in favor of
14th April 1943.
3.
14/4/1943. Issued by whom?
By the ex-landlord.
नाम बताइए ना।
अच्छा,
Balmari
Balmari.
उसके बाद वेस्टिंग कब हुआ?
14/4/43 को हुआ, उसके बाद वेस्ट हो गया।
कब? When did it vest with the state?
After Bihar land reform 1950.
अलग अलग एरिया का अलग अलग डेट ऑफ वेस्टिंग है। और उसके बाद जमींदारी रिटर्न फाइल हुआ होगा।
जी,
उसके बाद आपके नाम से रजिस्टर हुआ प्रॉपर्टी।
मेरे नाम से जमाबंदी खुला है 84 में।
84 में।
जी,
तो पहला जमाबंदी इतना दिन बाद क्यों?
वो
उस समय
इसलिए ज्वाइंट प्रॉपर्टी था, बहुत से भाई मर रहे थे, ancestors, and ultimately ये जमाबंदी
तो
was
ऐसा नहीं ना, आखिर पहले जब वेस्टिंग के समय किसके नाम से जमाबंदी अंडर द प्रोविजंस ऑफ बिहार लैंड रिफॉर्म्स एक्ट?
लैंडलॉर्ड के नाम से था, इसलिए रिटर्न
लैंडलॉर्ड के नाम से नहीं होगा ना, लैंडलॉर्ड रिटर्न फाइल किए होंगे,
फाइल किए,
रिटर्न फाइल किए होंगे तो उसके बाद बताए होंगे कि यू आर इन पोजीशन बाय वर्च्यू ऑफ हुकुमनामा, तो आप टेनेंट बन जाइएगा ना, लैंडलॉर्ड टेनेंट नहीं है।
हम स्टेट
कब बना आपका? 1956 में, 1950 में वेस्टिंग हुआ तो 1985 में रेंट रिसीट पहली बार कैसे आया?
नहीं, रेंट नहीं, जमाबंदी खुला है किसको?
उसके पहले
तो ओरिजिनल लैंडलॉर्ड का जो
नहीं हो
रसीद था
सकता
वही
है
था।
ना, नहीं हो सकता है ना सर,
हाँ,
नॉट पॉसिबल,
वही document
क्योंकि
वही था।
अल्टीमेटली वंस देयर इज वेस्टिंग, राइट, जमींदार फाइल्स रिटर्न्स, and after filing of the returns, if the property is found in possession of any of the rayyats by virtue of any deed, right, then that rayyat will become the tenant of the state, and zamindar, the role of zamindar will be
Cease.
over,
Yes.
right? So how it continued in the name of the zamindar?
No, it was not continued. Rather, an application was filed 1970 भूतपूर्व जमींदार द्वारा बंदोबस्ती के आधार पर ग्राम आई एम रीडिंग एक्सिक्यूट
प्लेन पढ़िए, प्लेन जो आपके प्लेन में है उसको ध्यान क्यों नहीं सुनेंगे? You read your plain, what was your case?
that originally the land of khata number so and so, plot number so and so, area 28.10 acre was Majarwa Khas land of landlord Banwari Lal of Chitra. That the suit property has been settled by the ex-landlord, namely Banwari Lal, under the Hukumnama dated 14th of April 1943 in the name of Roshan Singh, which was followed by delivery of possession to the city. Ex-landlord granted Jamindari receipt regularly in the name of the said Roshan Singh, representing the joint Hindu family. The said Hukumnama involved on the suit land as well as other lands measuring total 12.92 acres. That Roshan Singh and his brother were in joint cultivating possession of the land continuously. The said Roshan Singh was the Karta of the joint family. After vesting Jamindari estate, Roshan Singh and his brother continued in undisputed possession over this settled land, including the suit property. Much later, Roshan Singh applied for opening Jamabandi in his name. The said application remained pending, and much later was registered in 1978-79. Meanwhile, Roshan Singh died, issueless in the branches of his brother. His brother also died, and among them, Raj Singh and Pokan Singh died issueless. Bima Singh died leaving behind 20 number 1 to 5, and Handat Singh died leaving behind with 20 number 6 to 8. Gajadhar Singh died leaving behind 20 number 8. The plaintiff submits that by the revision order dated 14th of March 2024, in the aforesaid miscellaneous case number 7, the sub-divisional officer Chatra, along with the Jamabandi in the name of plaintiff number 1 to 5 and 8, and father of plaintiff number 6 to 7, namely so and so, in passing the said order, the landlord, the landlord SDO relied upon the order passed earlier and the proceeding of 145 CRPC, bearing PR case number 1 of 69, which was decided in favor of the predecessor of the plaintiff. The lands were also placed on order passed by land ceiling case number 727 of 84, in which the additional collector passed order in favor of predecessor of the plaintiff. That as the aforesaid Jamabandi was obtained in the name of plaintiff number 1 to 5 and in the name of others, obtained government receipt continuously, which is up to date. That it is pertinent to mention here that against the aforesaid order dated in 14th of July, passing miscellaneous and objectors, namely Anand Singh and others, had filed an appeal, which was finally disposed of by the
Commissioner Chakra in favor of the plaintiff. Thus, the plaintiff are the right owner and possessor of the said property issued since the time of their predecessor, since 1943, and their tenancy has been recognized by the state authority and paying rent regularly to the state, which is up to date. The plaintiff are joint owner, where plaintiff number 1 to 5, 6 to 8, and 9, and including 1/7 share of the said property duly mentioned in schedule B, item number 1 of the plan. That in the year 2009, plaintiff came to know that defendant number 5, Chairman Jharkhand State Electricity Board, Bhuvan Achi, was planning to set up a permanent station within the suit property plot so and so. The plaintiff in good faith believed that the project will be confined to the remaining area of plot number 2132 and not within the suit property. However, in and about September 2003, the started to make measurement within the suit property to which plaintiff objected. The Amin concern falsely presented that the measurement was tentative and would be finalized in the latter time in the presence of defendant number 4 believing this upon the Amin matter remains static at the stage of at that stage for long. That is September 2011, the plaintiff came to learn that proposed power grid will be constructed over the area of 20 acres, including over the suit property. Thereafter, by an application dated under the Right to Information Act 1804 for detailed in concerning area proposed for the power grid, not having received any reply for long, the plaintiff number 4 made an application on April 11 to the defendant number 3, including copy of the information sought from the Anchaladhikari. In response to the same, copy of the report of Karmachari was received containing false and misleading reply which were also contradicting to the Jamabandi of the plaintiff that was written pursuant to order of so-and-so SDU as being case number so. That thereafter the plaintiff made inquiries from the order representation to the defendant number 2 to 4 from time to time. Ultimately, the response of the oral direction of respondent number 2, the plaintiff number 4 submitted copies of their document to the defendant number 2 by application dated 27th of May 2024. The plaintiff number 4 followed up by the same by a written objection to defendant number 5. That lastly, the plaintiff application and an application to defendant number 2 to prayer for demarcation.
I've seen that.
Yes.
Why the learned court is writing that, but till today these plaintiffs have neither filed any rent receipts regarding the land in disputes of property.
Well, that is factually not correct because the exhibit I have produced, and if you not see the candidate order and the exhibits, that is there. Original memo registered to original copy.
Where it is registered to?
Copy to 3/3 original memo number so and so of Anchaladhikari with copy of registered to.
You must have exhibited registered to, isn't it?
It is perhaps 3/1. ये होगा आपका ये है मेरे पास उसमें 3/1.
This copy of registered to, certified copy registered to the file.
ये दे रहे हैं सूचना के अधिकार में डिपार्टमेंट हमारे सूचना के अधिकार को जवाब में ये लगाते हैं.
नहीं, सूचना के अधिकार से यहाँ पे एग्जिबिट नहीं मिलेगा. रजिस्टर्ड टू आपको या तो सर्टिफाइड कॉपी लाते हैं या
सर्टिफाइड कॉपी.
सर्टिफाइड कॉपी मींस
इसमें तो है सर्टिफाइड कॉपी 3/1 में देखिएगा.
145 के ऑर्डर के आधार पर आपका जमाबंदी खुल गया है.
जी
ऐसा खुल सकता है.
जी
145 के आधार
नहीं
पर
145 के आधार ही
because
नहीं
that
है
is there in the you have yourself stated that on the basis of the order passed under section 145
145
and also in the order passed under land ceiling
land ceiling.
which is that exhibit of land ceiling वाला exhibit बताइए कौन सा 145 के आधार पे तो कोई जमाबंदी नहीं खुल सकता है ना
नहीं वो कंसीडर किए हैं उसको
कंसीडर के लैंड सीलिंग वाला कहाँ है बिकॉज दैट इज अनदर बेसिस फॉर ओपनिंग जमाबंदी
Not exhibited.
145 का ऑर्डर एग्जिबिटेड है
हाँ, वो 145
लैंड सीलिंग का कहाँ है एग्जिबिट
लेकिन अपील में जो ऑब्जेक्टर गए थे उसको कंसीडर किया है वो भी
नहीं होगा ना ऑब्जेक्टर क्या ये मतलब इंटर पार्टी प्राइवेट पार्टी के बीच में झगड़ा चल रहा है तो उससे कोई लेना देना नहीं है उससे टाइटल नहीं कन्फर्म होता
हाँ तो टाइटल के लिए हमारे पास वो नंबर था रेटसिक था पोजीशन है डॉक्यूमेंट और हमने सूट में इसलिए लिया कि भाई सूट में आप डिक्लेयर कर दीजिए
सर टाइटल में देखिए तो वो क्या नाम है उस जजमेंट का याद नहीं उगली देवी है शायद आपको पता होगा देवी बाबू के साथ इतना साल रहे तो आपको उगली देवी तो एकदम जवान पे रहना चाहिए
35 साल का चीज 1 मिनट में याद नहीं आएगा लेकिन
आपको याद आ रहा है
या आएगा याद क्योंकि बहुत केस घूमता है नॉलेज अभी आप 3 डॉक्यूमेंट हमको याद आएगा फिर थोड़ा के बाद और एक डॉक्यूमेंट आएगा ऐसा नहीं है कि
नहीं
कोशिश नहीं
मतलब
करते
आई थिंक उगली देवी का ही जजमेंट है व्हिच इज अ वेरी फेमस जजमेंट एज आई रिमेम्बर तो केस में थोड़ा कंफ्यूजन है उगली देवी का ही जजमेंट है जिसने बोला हुकुमनामा फॉलोड बाय issuance of continuous rent receipt कंटिन्यूअस रेंट रिसीट किसको बोलते हैं आपके पास 2 डिस्क्रीट रेंट रिसीट है जमींदारी का उसके बाद वेस्टिंग के से कोई लेना देना आपका नहीं है डॉक्यूमेंट नहीं आया है उसके बाद यू अप्लाइड फॉर ओपनिंग ऑफ जमाबंदी फॉर द फर्स्ट टाइम इन द ईयर 1985 ऑन द
79 में हमने किया था वो
70
पेंडिंग और ऑर्डर आया है 84
ठीक है 79 में
हाँ,
अप्लाई किया था
79
85 में आपका आया है ऑर्डर which is primarily as the plaint reveals is based on 145 proceedings and one land sealing वाला आपने exhibit नहीं कराया what remains is 145 is a dispute
Possession.
between 2 parties
only respect to permission
इससे आपका टाइटल कैसे डिक्लेयर
टाइटल कोर्ट गया नहीं उस पर दैट इज व्हाट आई एम सेइंग
नहीं तो हम जा रहे हैं ना इसीलिए तो सुन रहे हैं नहीं तो क्या 1 मिनट में डिमांड कर
नहीं
लेकिन कोई पर्पस नहीं है ना डिमांड करके क्या करें
जब तक वहाँ पर एक तो की कोई जो डॉक्यूमेंट्स आया है उसका कंसीडरेशन नहीं है
तो कंसीडर करेंगे ना फर्स्ट अपील में
हाँ तो
आपका हर डॉक्यूमेंट कंसीडर करेंगे आप बताइए
so these are the exhibits. I cannot improve the cases. The fact is very clear. Hukumnama coupled with possession and the rent receipt given by the then landlord with the proceeding under Jamabandi that shows that we are continuous in possession and title is with me unless there is some contradictory document come from other sides.
Who is
My
the
doc-
other side? The other side, as per the written state, right? You have made only the state as party in this case. There is no other side,
No other side.
no private party. You were fighting 145 proceedings against whom? Some private party must
Anand
be.
Singh and others.
Yes, against private parties, right? So they are not concerned. They are not concerned with this property as of now.
No property description of the property is plot number वही है 20 एकड़ का जमीन में हम तो सब नहीं है हमारा केवल 5.23 एकड़ है वही है मेरा जमीन हम कह रहे हैं कि आप इतना बड़ा चंक जो है हो सकता है आपका हमारा आनंद सिंह का आई डोंट नो मेरा जमीन केवल इतना है जिसका डॉक्यूमेंट हम दे बस
ये जो आप जमींदारी हुकुमनामा एंड 2 जमींदारी रेंट रिसीट के बेसिस पर यू आर क्लेमिंग टाइटल ओवर द प्रॉपर्टी बट द फर्दर इस बीच जो हुआ वेस्टिंग हुआ रिटर्न हुआ देन जमींदारी रिटर्न के बाद क्या क्या अल्टीमेटली आउटकम हुआ And then the state, whether they recognized you as a tenant at that point of time, ये सारा कुछ missing.
This is the unilateral document by the state. We cannot add anything, but register 2 was before the lordship.
आपको एक बात बताएं, काम का बात, ये सूट जो है आपका टेक्निकल ग्राउंड में, आपने हो सकता है कुछ और डॉक्यूमेंट्स होता जो आप प्रोड्यूस कर पाते, बट यू हैव नॉट प्रोड्यूस्ड, यू क्लेम टू बी इन पोजेशन ऑफ, तो अभी आपको क्यों सूट डिसाइड करना?
नहीं, हम तो दूसरी बात बोल रहे थे, हम तो उस पर
नहीं,
बहस करने
हम भी आपसे पूछ रहे हैं।
हाँ,
तो अगर मान लीजिए कभी भी आपको डिस्पोजेस करने के लिए आएंगे या कुछ आएंगे, तो यू टेक स्टेप्स। अभी आपका क्या कॉज ऑफ एक्शन है? Why do you want to see? There are certain evidences which are not being brought on, as we can see it. Right? So why do you want to? If the suit is dismissed on a technical point, then under such circumstances, it will not act as a res judicata against you, will it?
No, I think it will,
No,
because
issue contested and decided.
but that
Issue
has
has not
been
been
done.
decided.
That has not been.
So res judicata नहीं लगेगा.
But my position may be disturbed. Cloud is there.
अभी कहाँ? This is what I'm saying.
They have constructed. They have constructed.
तो आप
Therefore,
recovery of
we have
possession.
claim for-
Just a moment. You have not prayed for recovery of possession.
नहीं, recovery of possession तो मेरा है. Possession में recover क्यों
अभी
करेंगे?
they have constructed बोल रहे हैं. Who has
हाँ,
constructed?
they have constructed forcefully. Therefore,
Right.
मेरा
But
prayer
there is
है.
no prayer for recovery of possession.
मेरा prayer है that if defendant forcibly acquired the said land, in such case, proper compensation of 80 lakhs be awarded to the plaintiff with interest and fair. So I was in possession. It was not decided by the court. Neither title has been gone by them, nor possession has been decided. Only on the ground 20 capital A of the specific agreement. And that act, that amendment has come in 2000.
You are claiming compensation.
I am alternatively I am claiming.
No, you are not claiming recovery of possession.
No, because my first period is very clear. My possession be confirmed. Why I will recovery of possession? My possession, I am already in possession. It is not their case that I am not in possession. Rather, they have failed to produce any document to the effect that I was not in possession. But court has taken the view without deciding the issues. The court says 21A bars the suit.
मुझे लगता है कि ये जो कोर्ट ने जो प्रोविजन ऑफ स्पेसिफिक रिलीफ एक्ट कोट किया है ना, वो कोर्ट ही गलत कर दी.
That is what I am saying.
No, that quotation is incorrect. Provision has been quoted. वो जो रिकवरी वाला जो क्लॉज है, वो कोट करना चाहिए.
But I think if we are on the judgment which is before us, and this even 28 is not applicable. It cannot apply
28.
retrospectively.
20A का तो कामयाबी नहीं है, इसका तो कोई मतलब ही नहीं है इसमें.
ये तो हम लोग तो इसी ग्राउंड में चैलेंज कर रहे हैं कि आप इसके चलते इंजंक्शन नहीं दे रहे हैं.
First appeal is co-extensive.
हाँ.
आपके हर एक पॉइंट को कंसीडर कर रहे हैं. One of the issues which was framed was whether the suit is barred by specific relief.
No, according to me, no. Because the Specific Relief Act, in Section 9 of the CPC, doesn't specifically expressly barred by any other provision of law. Otherwise, if it is civil nature, then suit is maintainable, and that I have fortified with my judgment. But I am on the issue that whether the court's application of mine is proper and in accordance with the procedure laid down in CPC. And
Specific relief act. 19 capital A कोड किया है ना इसमें?
20.
20. Is 92. Specifically,
You have to prove your title, right? Anyways, you present your whatever evidence you have placed. When were you dispossessed?
No, never. It was not disposed. They
You
have
said that building has been constructed.
the infrastructure they have constructed.
But you are in possession.
Was in possession, but by having that construction, impliedly I was out without. It is forcibly. I must say it is forcibly.
This-
Therefore, my relief is only to the respect of restraining them and confirmation of pole position. because they are interfering with my possession over the soup land.
Okay, apart from Hukumnama,
Yes.
you are relying upon the Zamindari rent receipts
Receipts,
and
the orders opening Jamabandi and appeal.
you read the Hukumnama, please. Read it. What is the description of this property?
There were developments. Hukumnama means Jari Babu Bhat. Translated copy. Banwari Lal, Shakim Chatra, Ahudi Jila, Hyderabad, Jamindari, Moda, Chokari, Thana, Puri, Jana, Cho, Jila, Hyderabad, under keyword number 2/3, Sahi, Banwari. Roshan Singh, Wald, Jana Singh, Mohtaba, Sorin, Chokari, Thana, Puri, Jana, Cho, Jila, Hyderabad, 2, Moda, Chokari, Thana, Puri, Thana, 59, November 28, under keyword number 2/3 under Ghair Majarwa Khas Jameen under keyword number 56 Rekwa 12/192 इसमें जमीन जिसका तहसील सलामी मौजा 80 रुपया को माल गुजारी सालाना वाली 4 रुपया 2 आना के अलावा शेष आज संबत 1999 साल में अलावे वेती कायमी अल औलाद जल्द
This is of the year 1943.
that is 14 3 okay. Looking for 1943.
Then you have these two
Receipts.
rent receipts, and then you have this proceeding sheet.
Then thereafter a certified copy of order receipt. One certified copy of order sheet dated 23rd of January. There are two exhibits. There is certified copy of order sheet of this case, appeal number 137.
See, there is a proceeding under section 145
There are
between two private parties.
145 in respect of two private parties.
Between two private
Two
parties.
private parties. It is just for the purpose of possession. It is
That's
not
right.
title. The document of title is not there, but it shows that I am in possession.
You have not claimed adverse possession, have you?
I am not claiming because
So you are claiming
I
title.
am in
so state-
possession. I am claiming mainly title.
That's
That's even the state government has issued rent receipts. 6 exhibit 6 series. But a very current receipt is also going on. The statement of name
and this 145 proceedings, what is the total area?
that is 12.92 acres. Is
Details of the disputed land.
yes.
Yes. Area is 1 acre 24 decimal.
there are two parts.
Yes.
One is
And this is area is 28 acres, 10 districts.
20 years total. We are in the part of that plot. That is also a statement in my plan. It is not in that part of this plot.
What is the area involved in this case?
In the plaintiffs? Yes, it is.
Suit.
Suit plan 5.3568 of the claim. One is 5 decimal acre and another is 0.35 acres. Total 5.3.
You see, this particular property is Khata number 36, plot number 969. This is not plot number 969.
No,
It is Khata number, no, it is plot number 2132.
Yes. It is plot number 213, khata number 36. City name and description. The detail of land is also mentioned in the order of 145 because that was in merchant, but it was only our plots were also. So we will get from HCB 3.
Then this is another proceeding under section 145. Why two proceedings are there under 145?
Exhibit 2 and exhibit 2.
There is another proceeding on 14th April 1966.
Yes.
Right.
It is 14.
Case number 65. This is also between two private parties.
Yes, but our land is there. You also will get from detail of the disputed land in village Chakori. Yes, Chakori, plot khata number 36. Pahla hai 969. We are not concerned with. 213432 acre area 5 acres, and next 2132 area 35 this. This shows that
That's right. So apart from that, these are the 145 proceedings, which is not referring to any hukumnama, nor it is referring to any kind of rent receipt, nothing. It is only talking about possession, and it is a proceeding between two parties.
two parties
Okay.
of the same village,
That's right. Both of them are claiming possession.
not over the same land, part of the same land and other land as well.
That's right.
There are two parts, and similarly,
You just come to next document.
yes, that is exhibit
Next document. Miscellaneous case number 3 of 70.
3 of 78, 79. This is exhibit 2/1.
जमींदारी बंदोबस्ती के आधार पर
जी, पर ग्राम चौधरी खाता नंबर डिफरेंट लिखी थी संबंधी पढ़ने का अनुरोध किया, and total is 12.92 acres. श्री लाल सिंह वगैरह ने दिनांक 30/7/77 को एक आवेदन पर दिया। आवेदन रोशन सिंह की मृत्यु हो गई है एवं उनके चल अचल संपत्ति के दो लोग उत्तराधिकारी हैं, अतः उन्हें रोशन सिंह के स्थान पर पति बनाया जाए। अंचल अधिकारी चोरी ने अपने प्रधान फाइन एंट्री 79 के आवेदक के उत्तराधिकारी होना स्वीकार किया। आवेदकों ने अपने दावे के पक्ष में एक सादा हुक्मनामा एवं जमींदार द्वारा दिया गया रसीद प्रस्तुत किया। इस संबंध में श्री द्वारिका सिंह एवं अन्य प्लॉट नंबर 16 अपना कब्जा होने का दावा किया, जिस पर टीआर केस नंबर 168 धारा 165 के अंतर्गत लोग प्रतिभागी के अंदर में अपना दावा प्रमाणित नहीं कर सके, अतः मामले न्यायालय ने उन्हें जमीन पर जाने से रोक दिया एवं रोशन सिंह का दखल कब्जा स्वीकार किया। रोशन सिंह का पर सीलिंग का भी मुकदमा चला था, जिसमें केस नंबर सेशन द्वारा अपर सीमांत अधिकारी ने आदेश दिया है कि रोशन सिंह की मृत्यु के बाद उनके जायदाद पर बीमा एवं है अर्थात जमीन बंटवारे के फलस्वरूप कार्रवाई बंद कर दी गई। विपरीत तथ्यों के आलोक में अवलोकन से आवेदकों के दावा से प्रतीत होता है, अतः आवेदकों के नाम से जमाबंदी खोलने की स्वीकृति दी जाती है। This is 14th of August 1954. Thereafter, incident 2/2. Order of appeal. रोशन सिंह ने अपने जीवन काल में ही अंचल अधिकारी थोड़ी से उक्त भूमि की दाखिल खारिज करने का अनुरोध किया था। विवाद बाद 3 of 2879 उक्त वाद के वर्तमान प्रतिवादी ने अपनी आपत्ति दी थी। यही से विवाद का प्रारंभ होता है। अपीलार्थी का यह भी कहना है कि भूमि सुधार उप समाहर्ता चक्र ने अपने आदेश 2480 के द्वारा उद्घाटित खरीद बाद में कार्रवाई को यह स्थगित रखने का आदेश दिया कि रोशन सिंह के विरुद्ध भू हदबंदी मामला संसद चल रहा है, जिनमें विवादित भूमि शामिल है, अतएव दाखिल खारिज की कार्रवाई पर रोक रखा जाए। अपीलार्थी का कहना है कि इस आदेश के बाद लंबी अवधि तक इस दाखिल खारिज मामले में प्रगति जानकारी नहीं रही और अचानक गांव में उन्हें यह अफवाह सुनने को मिला कि अनुमंडल पदाधिकारी चक्रा के द्वारा उक्त जमीन जारी जमाबंदी खोलने का आदेश दे दिया गया है। अपीलार्थी का यह भी कहना है कि अंचल कार्यालय में के प्रयास के बाद भी सूचनाएं नहीं मिली। आदेश के अधिक लाभ को मिलने का आवेदन दो टाल के बाद बिना में प्राप्त हुआ, तब यात्रा का अनुमंडल पदाधिकारी चक्रा की ओर से आदेश दिया गया कि रोशन सिंह को पदाधिकारी का जमाबंदी खुल जाए। फलस्वरूप विलंब से यह अपील दायर किया गया। विलंब की शांत करते हुए इतना किया इस आलेख में उपलब्ध का नहीं रहने के आदेश और पक्ष को सुनने के उपरांत इसका विस्तार किया जाता है। विद्यार्थी ने यह कहा कि अनुमंडल पदाधिकारी का यह आदेश असंवैधानिक एवं चक्राधिकार के परे है, न्यायपूर्ण है और सुना जाना चाहिए था। आदेश पारित करते समय भू हदबंदी मामले में भी रखा गया स्थिति को भी देखा गया। अनुमंडल पदाधिकारी 145 से धारा यहाँ केस नंबर 16 में पारित आदेश प्रभावित हो अनुमंडल के 12.92 एकड़ का खो दिया, जबकि धारा 145 के अंतर्गत में की गई कार्रवाई में प्लॉट 5.35 एकड़ प्लॉट नंबर टोटल अनुमंडल पदाधिकारी 9.3 का नाम खो दिया गया। विराटी का यह भी कहना है कि उन्होंने दाखिल खारिज की कार्रवाई में आपत्ति की थी कि विवादित भूमि जल मजरूआ खास है, प्लॉट नंबर इतना इतना दीवार और चल रहा है, प्लॉट नंबर इतना इतना नाला के रूप में अंकित है, जो आसपास के भूमि के लिए सिंचाई का एकमात्र स्रोत है। विवादित भूमि में अपनी लाठियों के लिए प्लॉट नंबर इतना 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 16 भूमि प्रति है एवं प्लॉट नंबर इतना भूमि के साथ मिला दिया गया है। लाठी के अनुसार इनमें स्तर का सत्यापन नहीं किया गया है। मैंने अनुमंडल अधिकारी के पारित आदेश विवाद संख्या सेक्शन से अवलोकन किया। अनुमंडल पदाधिकारी ने प्रदेश को धारा 145 के आधार माना। उन्होंने उल्लेख किया है कि उनके सगा हुक्मनामा और जिम्मेदार द्वारा दिए गए रसीद उनके समक्ष प्रस्तुत किया एवं द्वारिका सिंह द्वारा प्लॉट नंबर 16 पर रोशन सिंह के दखल खारिज का आपत्ति की भी कार्रवाई के अंतर्गत खारिज कर दी गई। निबंधन पदाधिकारी को यह भी अंकित किया कि भू अधिकारी के मामले में विस्तार हो चुका है और केस नंबर इतना द्वारा ऊपर से मामला जारी करके आदेश दिया कि रोशन सिंह की मृत्यु के बाद उक्त जायदाद के उत्तराधिकारी भीमा सिंह हो गए तो स्वरूप प्रमाणपत्र ने जमाबंदी खोलने का आदेश दिया। निबंधन पदाधिकारी के आदेश के अनुसार ऐसा लिखा है कि अभिव्यक्ति की सुनवाई का पर्याप्त अवसर मिलेगा। निबंधन पदाधिकारी जमाबंदी खोलने संबंधी सक्षमता पर कोई विवाद नहीं है। विवेक के तत्कालीन डॉक्टर सोशो आवेदन जांच प्रतिवेदन लिखा हुआ है। यह पत्र इस अभिलेख में आया है। यह अभिलेख देखने से पता नहीं चलता है, लेकिन दखल कब्जा की स्थिति में इसमें प्रकाश पड़ता है। यह प्रतिवेदन में उन्हें बात देखी गई है कि रोशन सिंह एक हुक्मनामा बनवारीदार उनके जमींदार द्वारा दिलवाया गया है। जमीन के विवरणी वही है जो आदेश में पहली बार अंकित किया गया है। उनका निरीक्षक ने यह भी उल्लेख किया कि प्लॉट नंबर 16 बढ़ती पड़ी हुई है और इसमें किसी में जोड़ नहीं पाया गया। प्लॉट नंबर 213 भूमि संरक्षण विभाग द्वारा गत वर्ष मिट्टी कटाई की गई, जिसके बराबर प्रति रहा करता था। प्लॉट नंबर 989 है, परंतु यह जमीन रोशन सिंह के दखल कब्जे में है। प्लॉट नंबर 11 गोविंद सिंह के अपना तनाजा बताया।
आप उनको ये देखिए, ये जो ऑर्डर है, जो अपीलेट कोर्ट का ऑर्डर, एग्जिबिट 2.2, पेज नंबर 5, इंटरव्यू पेज 5,
प्लॉट का डिस्क्रिप्शन
प्लॉट नंबर 2132 है ना आपका, 2132 में देखिए
जी 5.32 यह
5.32
है।
हाँ,
हाल फिलहाल में पक्षकारों के बीच से क्रिमिनल केस हुआ है।
तो ये जो आपका पुराना जो ऑर्डर है, वाद संख्या 140 ऑफ 64-65, ये कौन सा केस है? 140 ऑफ 64-65, इट इज मेंशन एट द टॉप।
ये और पार्टी लोग का होगा, मेरा उसमें केस में केवल
तो आपका तो इसमें भी तो क्लियर कट आपके नाम से तो नहीं बोल रहा है 2132 they are not stating it in your favor completely.
नीचे में देखिए, प्रतिवेदन में यह भी माना गया है कि रोशन सिंह के दावों के विरुद्ध गोविंद सिंह अनंत सिंह ने प्रतिक्रिया की है, लेकिन सभी प्लॉटों के संबंध में उन्हें आपत्ति नहीं हुई है। अंचल निरीक्षक के प्रतिवेदन से यह भी कहा गया कि रोशन सिंह के दखल में है, उनकी बंदोबस्ती होने में कोई आपत्ति नहीं दिखती है। उपयुक्त विचारण के कुछ बातें निर्विवाद रूप से सामने आती है। पिलाठी ने अपने आवेदन में मात्र रोशन सिंह का जमाबंदी को खारिज करने का निवेदन किया, तो अपने नाम में जमाबंदी खोलने का कोई निवेदन नहीं किया। और 145 के कार्रवाई में
प्राइवेट डिस्प्यूट नहीं है सर, प्राइवेट लोग नहीं है। See, it is these proceedings are between two private persons.
स्टेट तो नो है,
State is nowhere. Now you have made only the state party.
सूट में तो जो है
Right. सूट में आप तो उनको पार्टी बनाया, तो ये सारे ऑर्डर स्टेट के ऊपर कैसे बाइंडिंग होते हैं?
नहीं, जो स्टेट तो इसका ऑब्जेक्शन करते हैं ना कहीं पे,
कहाँ पे?
रिव्यू रिकॉर्ड में हम मेरे
State
पास
के
क्या
ऊपर-
ऑप्शन था, मेरे पास 2-3 ऑप्शन है। एक हुक्मनामा का है जिससे हम टाइटल ड्राइव करते, मेरे असिस्टेंट करते हैं। दूसरा कि जमींदार का रेंट रिसीट है, उसके बाद हमारा जमाबंदी खुलता है। रेंट रिसीट स्टेट ऑफ झारखंड का इशू होता है। कंटिन्यूअस
कंटिन्यूअस नहीं, कंटिन्यूअस नहीं है। 45 you see 42 43 में and 48 43 and 48 there are two rent receipts issued। हाँ, उसके बाद सीधे 85
हाँ 79 में जो सूट फाइल हुआ उसका
बीच में।
हाँ, तो उसका हमने स्टेटमेंट दिया है कि अपडेट रसीद आता है मेरे पास।
कहाँ से स्टेटमेंट से थोड़ी चलेगा, आपको तो सारा अप टू डेट रेंट रिसीट लगाना चाहिए था ना। कंटिन्यूअस रेंट रिसीट, there has to be continuous rent receipt
that we have stated in
even till the date of vesting, even till the date of vesting जमींदार का continuous rent receipt होना चाहिए, otherwise ये unregistered हुक्मनामा का कोई मतलब नहीं।
ऐसा according to my submission registered document होना और coupled with possession होना, दोनों में अंतर। हमारे समझ से हुक्मनामा अनरजिस्टर्ड है और coupled with possession है, then registration is not required. But what I said in para 7 of the plan that a forced jamaabandi was opened in the name of plaintiff number 125 and in the so and so who obtain government rent receipt continuously which is up to date.
कहाँ है
Para
continuously?
7 में.
Where have you proved continuously up to date?
उसमें क्या हुआ होगा हम I can
Assumptions से तो नहीं.
that is what I am saying.
Continuously up to date नहीं है. Otherwise जमींदारी खोलने के लिए आप नहीं बोलते. आप सिर्फ म्यूटेशन के लिए बोलते हैं कि भाई मेरे एंसेस्टर का डेथ हो गया है, आप म्यूटेट कर दीजिए. जमींदारी जमाबंदी खोलने का कहानी नहीं होता उसमें.
लेकिन ये मेरे टाइटल का डिफेक्ट नहीं हो सकता है जो उनका
आप प्लेंटिफ हैं, टाइटल आपको प्रूव करना.
जी तो सूट
Normally any transfer has to be by a registered deed, but this court has acknowledged certain transfers through hukumnama provided it is followed by issuance of continuous rent receipt. These two discrete rent receipt is not a continuous rent receipt.
and thereafter state of government
State of Jharkhand का State of बिहार आपको कहाँ रिकॉग्नाइज किया? 85 के पहले या मान लीजिए 79 को आप अप्लाई किए.
Exhibit 63 है 6263
आप देखिए 85 का rent receipt.
वो एग्जिबिट जितना हुआ था उस समय तक का ये
नहीं उस समय तक का बात नहीं है सर. What there is a huge gap between 1943 and maybe 1948 till 1979.
यस
There's a huge gap,
लॉर्डशिप में फैमिली
and you have not produced anything कि लैंडलॉर्ड का क्या हुआ, उसने क्या रिटर्न फाइल किया, आपका जमींदारी खुला, आपका जमाबंदी खुला, नहीं खुला, क्या हुआ?
Now your lordship may appreciate two more facts on that issue itself. The villagers who are
सर टाइम हो गया, कल सुनिए. कल कुछ रखें क्या? कल कुछ सेकंड आप कल मान आप वो आप लोग बराबर उंगली देवी साइड करते हैं, कौन सा जजमेंट साइड करते
उंगली देवी तो दूसरा जो है
हैं? हाँ
उंगली देवी तो दूसरा उंगली देवी अपने
कौन सा लोग जजमेंट साइड करते हैं बराबर?
उंगली देवी है कि वही आप रजिस्टर्ड हुक्मनामा जो है उस पर
उसी पर है ना?
लेकिन सिर्फ पोजीशन के लिए वो उस बात
नहीं सिर्फ पोजीशन उसमें ये है कि अगर देयर इज एन अनरजिस्टर्ड हुक्मनामा
कोलेटरल पर्पस के लिए
फॉलो नहीं followed by issuance of continuous rent.
हाँ कंटिन्यूअस रेंट.
लेकिन इनका तो दो रेंट रिसीट है जमींदार का, उसके बाद yes prior to vesting.
1968 का है उसमें
after vesting it is our provision and it is not control of the government.
आप क्या कर रहे थे? एक भी गवाही में दिए हैं.
Yes, this is the mistake.
मिस्टेक क्या? मिस्टेक है तो
But you are not
जमीन से हाथ धोइए. इसमें
initially-
मिस्टेक का कोई सॉल्यूशन थोड़ी है हमारे पास.
Initially, lordship in the WSC lordship raised the issue then joined of the party of lordship only by the state.
Non-joined means
Non-joined means your lordship the dispute between the both party placed the document under section 145 CRPC regarding this land your
आप एक
lordship.
बात बताइए. If you are claiming title, how are you concerned that any third party is not a party before this? How are you concerned?
Because the entire document is produced by the plaintiff your lordship regarding the dispute between the two private parties.
We don't bother about it.
So
You see, dispute between two private party will not bind you. If you are claiming title independently, it's independent title.
but entire area is in 28 acres. He claiming the cost only 5.35 acres. Acquired by the great lordship 20 acres.
जरा बोलिएगा उन्हीं को भी.
कल
कल तो नहीं हो पाए. The Wednesday को है क्या? Next Wednesday को just running. The arguments have remained inconclusive. Post this case for further hearing on next Wednesday at 2:15 as first case to be treated as part of. उगनी देवी का जजमेंट लेके आई है. उसको कई जजमेंट में हम रिलाई किए हैं. वो सब जजमेंट भी सुप्रीम कोर्ट से आपको
अनरजिस्टर्ड हुक्मनामा इनएडमिसिबल है. अब ऑनरेबल सुप्रीम कोर्ट का देन देगा.
आपके अगेंस्ट में थोड़ी बोल रहे हैं, बच्चे आपके अगेंस्ट में थोड़ी बोलते
नहीं नहीं,
हैं।
हम उसको नहीं बोलते।
Citation
Then he should also examine it.
दोनों हम लाएंगे, उसको भी लाएंगे और सर
देखिए ये भूल गए, ये कितने सारे केसेस
ये
देवी
किया है।
बाबू के भी बहस किए हुए हैं।
हाँ,
उनकी
1968
भी
का उगली नहीं बना, फरता चुहा मत हो कैसे।
कुछ पार्टी का नाम याद
हाँ, नाम नहीं नहीं।
हमको पता है ना, सर थे देवी बाबू के साथ।
हाँ, नहीं, नहीं।
थे ना सर आप?
हाँ हाँ,
गलती हो गई, हम लोग सीखे नहीं तो।
सिविल मैटर्स बहुत दिनों तक टेकअप भी नहीं हुआ ना, इसीलिए मौका भी नहीं पड़ा होगा बीच में। पिछले कई मतलब
आप तो सेकंड अपील ऑलरेडी रिसीव करती थी तो
नहीं, अब तो हो ही रहा होगा।
हाँ, वो जो बहुत सारा एबीए डब्ल्यूपीसी
मल्टीपल नहीं, सेकंड अब सिविल केसेस के लिए अगर आप स्पेशल बेंच नहीं बनाइएगा
हाँ,
अपना, तब तक नहीं होगा, क्योंकि बाकी सब मिसलेनियस काम दीज टेक क्वाइट सम टाइम।
हाँ, जब तक फुल डे नहीं होगा नहीं होगा।
फुल डे या हाफ डे भी फिक्स करिए तो हो जाएगा, धीरे धीरे होगा।
He's done 2 years.